Good afternoon, everyone. My name is Maya Luria with TMC for Seniors. And today we're wrapping up the end of our Women's Health Month. And we're going to do this on the financial side of things today. I have Shanelle Schmitz here from Zack Schmitz, and she is going to share with us all about legal planning for women. Thanks for being here, Shanelle.
Yes, thanks for having me, Maya, and good afternoon, everyone. So today, what I plan on getting into is just some common legal planning concerns that women have and some tips for addressing those. So if you could please go to the next slide. So here's my contact information. So anyone who has questions about this presentation, you can feel free to reach out to me and I can see if I can address those questions. We'll also leave some time at the end to address those questions as well. Next slide. Here is a legal disclaimer, basically saying that any information presented in this PowerPoint shouldn't be construed to be formal legal advice, nor the formation of a lawyer or attorney-client relationship. If any results are set forth herein, such results are based upon the facts of that particular case and do not represent a promise or guarantee. So please contact a lawyer for a consultation on your particular legal matter. And there are a lot of great estate planning attorneys here in Tucson who can assist you and discuss with you your specific needs. And that's part of this presentation, just going over how important it is to form your estate plan to your specific concerns and your specific needs. Next slide, please. So some of the common planning concerns that I hear from women are, who is going to take care of my minor children if I pass away? Who is going to take care of my adult child who is incapacitated with the disability if I'm not here any longer? Another common concern that I receive is if you're taking care of your spouse who has an issue with dementia or Alzheimer's, for instance, and they're not able to take care of themselves, who is going to take care of my spouse upon my death? Another common planning concern that I hear is if you're a widow or a single woman with no children, how do you make sure that you're taken care of if you become incapacitated? Or what if you outlive your spouse and become incapacitated yourself? Who's going to take care of you at that point? Another common concern that I hear is, what happens if I die before my spouse and my spouse is vulnerable and taken advantage of? How do I protect my assets to make sure they're used for my spouse's care, but also preserved for my children's inheritance? How do I protect my children after I'm gone? Next slide, please. So what we'll do today is we'll go over the basic essential estate planning documents that you should have within your estate plan and how some of those documents can address your concerns. Next slide, please. So a will is instructions to the court as to what happens after your death. So it's only effective upon your death. And you can name your personal representative or executor in your will. You can create trusts, also known as testamentary trusts. You can designate where your property goes upon your passing. And you can also incorporate a memorandum of personal property. So what we usually do for our clients is we'll have the will, but we'll incorporate a memorandum that's separate outside of the will where they can designate where their personal property goes. And it's easy to change. It's more flexible than having those designations within your will. And it also goes forward and designates what happens for payment of debts and taxes. So using your will, next slide, please. Using your will to address some of the concerns that I previously mentioned. So first, you can name a guardian for your minor children. So under Arizona Revised Statute 14-5202, you as a parent of a minor child can appoint through your will a guardian for your unmarried minor. And this will specify who you want to take care of your child if something happens to you. Also, you can name a guardian for an incapacitated unmarried adult child. So say you're the caretaker for an adult child who has special needs, and you're concerned about what's going to happen to them upon your passing. You can, in your own will, designate who should serve as their guardian upon your passing. That way you have a plan in place to take care of their needs after you pass away. You can also name a guardian for your incapacitated spouse. So let's say your spouse has dementia or Alzheimer's. In your will, you could name who you want to be appointed as their guardian upon your passing. So those are important things to consider whenever you are establishing your will. The next document would be a trust, also known as a living trust or revocable living trust. So that's essentially a private contract between you as the trust maker, you as the trustee, and you as the beneficiary while you're alive. And within your trust, you can name who is your successor trustee or successor trustees. And we'll discuss a little bit more about tips on choosing a successor trustee. And essentially what you're doing within your trust is you're providing instructions to your successor trustee about what you want to happen if you were to become incapacitated or upon your death. And the idea is to transfer all of your assets into the trust so that whoever is serving as your successor trustee has an easy time to manage those assets that are within the trust. Next slide, please. So during your life, a trust is very useful for incapacity planning. It's one of the most flexible tools to use to plan for if you were to become incapacitated. So within your trust, you can provide instructions for how you want your assets to be administered. So you can state that you want it only used for your benefit, or you can also provide for the benefit of you and your dependents. So you could be as specific as you want to regarding what those assets can be used for if you were to become incapacitated. So let's say you do have a special needs child who is dependent on your care while you're alive. You can always provide within the trust that those trust assets can be used to take care of them. You can also have a different successor trustee during your life versus at your death. So sometimes my clients are worried because they may not have family or friends that they trust. So some other options that they can have versus family or friends is having a professional trust company or a licensed fiduciary serve as successor trustee. Some other concerns are, let's say you're leaving everything to your sibling. Let's say you're single, you don't have any children, and you're leaving everything to your brother, but you don't want your brother to manage your assets while you're alive because you're concerned that he might just want to preserve everything for after you die and not necessarily use those assets for your benefit. So in those types of situations, you may want to speak to a professional trust company or a licensed fiduciary to make those decisions and manage those assets for you. And it's always a good idea to meet with whoever you're thinking about putting into your document because you want to develop a relationship with them. You want them to know what you would want since they are stepping into your shoes if you were to become incapacitated or upon your death. Next slide, please. So at your death, your trust generally becomes irrevocable. If you're married, it may not become irrevocable if you have a joint trust, and we'll discuss that a little bit more in a few minutes. But typically it becomes irrevocable, meaning that it can't be changed or amended after you pass. And you're going to provide instructions in your trust for how you want your assets to be managed and distributed. And you can specify who you want to receive your assets upon your death. So this is important because a trust allows you to provide certain protections for your beneficiaries. So a lot of times we'll have clients who are concerned that maybe their husband, they think that he may end up remarrying after their death if they predecease him. And they're concerned that he's going to marry someone else and leave everything to the new wife and disinherit all their children. Even if they're joint children, some of our clients have these concerns. So there are certain tools that you can use within your trust to address these concerns. One common method is to have your trust split into two separate trusts. So that'd be like an A-B trust. So we generally call an A trust above ground trust, just to remember it. So that would be the surviving spouse's trust. The B trust, below ground trust, the deceased spouse. So upon the death of the first spouse, it would split into these separate trusts. And within the B trust, assuming that you die first, you can specify that you want certain restrictions in place as to how your spouse can use those assets while they're alive. So maybe they can only use them for things such as health and maintenance and support. So they can use them for like paying medical bills if they need help paying medical bills, but not necessarily to go and buy a Ferrari or go to take the new wife to Vegas. So you can specify those types of things, and you could also make it to where your side, in the B trust, it's irrevocable. So your spouse wouldn't be able to change the beneficiary. So it would ensure that your children would get whatever's left in the B trust. You can also have remarriage provisions in there as well, so that if your spouse does get remarried, you can provide that they have to have a prenuptial agreement, or else they're disinherited and could no longer have access to the funds in the B trust. So there are multiple ways to protect your spouse from themselves if you have concerns that they may be vulnerable, and also to protect your children or whoever your residuary beneficiaries are. There are also other ways to plan for these issues. There's a joint pour-over trust to separate individual trusts. So maybe you and your husband have individual trusts that are separate because you have separate property that you want to be treated differently upon your death. And you can have your joint property in a pour-over trust and have that pour into these separate trusts. So there's a lot of different options and flexibility within drafting your trust that you want to consider so that it addresses any of your specific concerns. The next document that's very important to have, even if you do have a trust in place, is a durable financial power of attorney. And that has certain provisions in it that would protect you if you become disabled, because it's essentially allowing someone to step in your shoes. Usually we're recommending very broad powers to our clients. So whoever they have listed would be able to do things like file their taxes, collect their mail, care for their pets, etc. But you would be in charge of what those powers are, and you can always limit those powers too. Now, the role of power of attorney is a great responsibility and liability for the agent. So you always want to make sure that you are choosing someone that you trust. And if you are in a situation where you may not have friends or family that you would trust in that role, that you would trust to manage your assets, you can always, like we discussed earlier, have a professional trust company or a licensed fiduciary step in that role. And the problem that we do run into often with financial powers of attorney is they may not always be accepted. So in that case, there may need to be a conservator that's appointed through the court. But within your power of attorney, you can specify who you would want to be the conservator if that were the case. Next slide, please. So the next document that's very important to have is a healthcare power of attorney document. And within that, you would nominate your healthcare agent. So who do you want to make your healthcare decisions for you if you are unable to do so yourself? And this person doesn't necessarily have to be your spouse or your children if you do have a spouse and children. If you don't trust anyone to follow your directions or make decisions that you would want to be made whenever they step into your shoes, you can always discuss with a professional licensed fiduciary whether they would be willing to serve in that capacity as well. So there are other options. And you can nominate who you would want to be your guardian if a guardianship were ever needed for you. You can also specify, which I find a lot of my clients wanting to do, is who you do not want to serve as your guardian. So maybe you don't get along with your parents, or maybe you don't trust one of your one of your kids to serve in that capacity, then you can specify that you do not want the court to ever appoint them to be your guardian. And you can also include funeral and disposition arrangement authority within your healthcare power as well. And even if you don't have funds to hire an attorney to help you set up a healthcare power of attorney, it's pretty easy to do so on your own. You can download free forms from the Arizona Attorney General's website for healthcare power of attorney, living will. So next slide, please. So the living will is the next important document to specify what you would want to happen if you were in a position where you were terminal. The doctors were basically saying there's nothing else they can do for you, whether or not you would want life-sustaining treatment beyond comfort care that would only serve to essentially prolong your life. So you can have that specified within your living will, and you can also specify whether or not you want it to be effective if you were to become pregnant, which is an important decision for women. Next slide. So the next document is a Hipaa authorization. So that allows for the release of medical information, and that also may be included in your power of attorney. So that's another important document to consider. Next slide, please. So some potential problems faced by women if they have no estate plan in place. So let's use a common example that I run into often. So you're not legally married to your significant other. And if there's no estate plan in place, you have no right to your significant other's property upon their passing. So under Arizona law, if they don't have an estate plan in place, Arizona law would essentially provide what happens to the distribution of their assets. So if they don't have a surviving spouse, the entire estate would pass to their decedent's descendants. Then it keeps going down the line, as you can see on this slide, descendants' parents, then descendants of decedent's parents. But you, as their significant other, if you're not legally married, would have no right to their property if they don't have an estate plan set up that way. You also wouldn't have any decision-making rights. So you wouldn't be able to make any decisions about their health care or financial decisions if they became incapacitated. So if you are relying on them for financial support, it's really important to convince them to get an estate plan in place, making sure that you're also taken care of as well. And you wouldn't be able to make any funeral arrangements at their death because you wouldn't have any of those types of decision-making rights. So it's important to think about that and try to make sure that they have an estate plan in place as well. And another common problem that we see is with blended families. So if there's no estate plan in place, not all of their property would transfer to the spouse. So if the decedent is survived by a spouse and one or more children from a previous relationship, then the surviving spouse would only get half of the deceased spouse's intestate separate property and none of the deceased spouse's share of the community property if the deceased spouse did not have an estate plan in place. So the surviving children would get half of the community property and half of the deceased spouse's intestate separate property. So this is concerning, and this is something, if this is concerning to you, this is something that you want to talk to your spouse about to make sure that they have an estate plan in place, and also to make sure you have an estate plan in place if this situation sounds like something that could affect you. And now I'll open it up to any questions that anyone has.
So thanks so much, Shanelle. I'm going to remove that so we can talk. I did have a couple of questions that come in, and I know this topic is super confusing as you go through it, just all the things that you really do need to consider. Can you tell us how often you suggest that somebody might want to update their will?
So we generally recommend to our clients taking a look at things every 2 to 3 years because their personal situations may change. Maybe they have new grandchildren they want to include. Maybe they want to disinherit a family member. So and also the law does change often, so they would want to think about those things and maybe see an attorney every 2 to 3 years to go over these things.
Okay. And if somebody has a trust created in another state, I have somebody who said they had a trust created in Michigan. How different are the regulations from state to state? Would there be a difference for Arizona compared to Michigan?
I don't know the specific laws in Michigan because I'm not licensed to practice in Michigan, but I always advise clients, if they're moving out of state, they should be talking to an attorney that practices within the state that they're moving to make sure that everything is proper and in place, correct. Basically that it follows whatever the state that they're moving to, those specific laws.
And would the power of attorney be the same case? Does that follow you from state to state, or is that different per state as well?
So that can be different per state. We usually recommend, like if someone's a snowbird, for instance, and they reside in a different state and come visit in Arizona for half of the year, we usually do recommend that they have a financial power of attorney and then the healthcare documents, healthcare power of attorney, living will, and Hipaa authorization specific to Arizona. So it is state specific.
Okay, so basically you'd have two. You'd have one in each state. It could be the same, but you just using that paperwork.
Right.
I had somebody ask, what would the main differences be between men and women for legal planning? Is there anything different that men would be doing, or that you see that comes up maybe more with men than it does with women, or vice versa?
Well, a lot of times we do see that the men die first, and so the woman is usually survives statistically the man. So that's why I did kind of go over some of the examples where maybe the woman is widowed. So I guess it would just be important to have these types of documents in place, even if you are a man. So some of the concerns may be a little bit different about what happens after your death or if you become incapacitated. But I think men also face a lot of these same problems that we discussed.
Sure. And what about, I was thinking about sort of the power of attorney, particularly the medical power of attorney. I wanted to share with everyone that we do offer some help here as well. That you can pick up the forms. We do have the 5 wishes here, along with the Attorney General's packet available. And we do have somebody that will meet with you to discuss those as well. So if anyone ever has any questions, but I do want to also make sure, Shanelle, that your information, and how you're seeing people right now, or if you're mostly seeing them virtual, and I am going to put your information back up here on the screen too, just so that that's there.
So right now we have both options through our office. So my law partner is Ronald Zack, and he's meeting with people in person, and I'm also doing the virtual meetings, so I can do Zoom or telephone consults for the signing of estate planning documents. So those do have to be in person, but we do take steps to try to make sure that everything is safe if someone has concerns about coming into the office for a signing.
Wonderful. Thank you so much for sharing all of that. I think it's really important, and I know there's always lots of questions that come up, and so, if questions regarding trusts and wills and their power of attorneys, and just making sure that they're choosing the right thing for them is always important. So definitely a great recommendation to be able to meet with somebody. So I appreciate that. That is everything that has come in today, and I just want to thank you so much. You always bring us a wealth of information, Shanelle, whenever you come, and I appreciate all the time that you spend with us to really share your knowledge and making sure that we are prepared for the future, and that is super important. So thank you for being here. We, as I mentioned, we are wrapping up our Women's Health Month. Next month is going to be all about hearing issues, hearing as we age. So be sure to look for all of those classes that are coming up for for June. Our first class will actually be, we actually have a class also on balance, which is called Worried About Your Balance, coming up on Monday, June 7th. With PCOA's Matter of Balance program. If you are interested in finding out more information about that, please give us a call at 520-324-1960. Thank you again for being here, Shanelle, and everybody
Maya.
have a great day.
You too. Thanks.